The issue for determination is whether there are compelling reasons to deny the accused bail. A preliminary issue arises from the defense submission that the court is being asked to revisit a decision by Lady Justice Stella Mutuku in Republic versus Sarah Wairimu Kamodo 2019, where the issue of bail was conclusively determined on 11th October 2019. It is straight law that a court cannot sit on an appeal over its own decision, and if proven, this would warrant dismissing the objection. The facts are undisputed. The accused was first arrested in 2019, pleaded on 3rd October 2019, and was discharged after a nolle prosequi in HCCR 60 of 2019. The matter later became inquest number E009 of 2023, which terminated on 2nd October 2024 after new evidence prompted a review by the DPP. The accused was later arrested and charged in this file. It is established that the accused and the two witnesses were engaged in an employer-employee relationship, characterized by a power imbalance inherent to superior-subordinate dynamics. The evidence on record indicates that attempts were made by the accused or her associates to intimidate the witnesses, thereby deterring them from giving testimony against the accused. The defense contends that 6 years have elapsed since the commission of the offense, hence diminishing the probability of witness interference. I do not agree with this thinking. Interference may manifest at various stages, including during investigations, throughout the trial, or subsequent to the filing of charges, and may involve actions by the accused, witnesses, or other parties. I do not agree with the defense counsel's argument that the passage of time does ipso facto mitigate against the threat to witnesses. The passage of time does not inherently reduce the risk of intimidation or interference. This trial, being in its early stage with no witness testimony yet presented, underscores the ongoing relevance of potential threats. It is a factual misrepresentation to assert that threats against witnesses are necessarily most imminent around the time of the commission of the offense. Threats can indeed occur at any point in the timeline of a case, prior to, during, or following the act, through the investigations, during the trial itself, and even post-trial. Given the unpredictable nature of when and from where threats might arise, courts maintain the authority to implement protective measures for witnesses at any stage of the proceedings to ensure their safety and the integrity of the judicial process. This capability reflects the judiciary's recognition of the continuous and evolving nature of witness vulnerability. From the analysis above, the likelihood to intimidate or interfere with witnesses has been proven with sufficient evidence. Moreover, this is a case of public interest where a life was lost in the most heinous manner. Article 24 of the Constitution appreciates that human rights can be limited. The provision sets out a limitation criteria that should be followed when limiting rights. The limitation is therefore a synonym for justifiable infringement. The infringement will not be unconstitutional if it takes place for a reason that is accepted as a justification for infringing rights in an open democratic society based on human dignity, equality, and freedom. The right to bail and the right to liberty can therefore be limited when circumstances so demand. This case requires balancing the accused's right to liberty and bail against the administration of justice. It is my considered view, therefore, that the principles of justice and public interest outweigh the accused's right to liberty at this stage. The court must safeguard the trial's integrity by protecting witnesses and preventing potential interference. In the circumstances, I decline the accused's application for bail. The accused shall remain in custody until after the two witnesses have testified. The accused is at liberty to revisit the issue of bail at that point. That is the ruling of the court.